How are you?
Fine, ma'am.
So you studied the features?
Yes, ma'am, little bit.
Okay. So is that part clear?
Yes, ma'am.
And otherwise, how is your studies going on? Your exams are also coming, right?
Yes, ma'am.
So how is your studies going on?
Now only little bit starting from every subjects.
Okay, fine. So you start studying this, okay? Because before exam, there are cases and all also, right? It will be difficult to remember them. Okay, so we have like one topic left from this Motor Vehicles Act, and also few things are remaining from that Unit 5. All right, so apart from that, we'll also start with some concepts from Unit 4. Okay, so what is Unit 4? Have you like seen the syllabus? Unit
Yes,
4, what is,
ma'am.
or like in your college, have they started with it?
Ma'am, in our college they finished everything.
Oh, Unit 4 is finished also, huh?
Yes, ma'am. Unit 5 also finished.
Oh, then complete syllabus finished?
Yes, ma'am.
Okay. So what are they doing now? No classes, study leave, or what is it?
They're not taking class, ma'am, but not study leave, ma'am. But some subjects are going on, ma'am. Other
Okay.
subjects.
Okay, fine. So do you get notes and all from college, or it's just like the lecture thing?
Lecture only, ma'am. They will say go to library and search books.
Okay. So for this, right, torts against property, what all things did they discuss? Trespass, what else they discussed?
The trespass to land they have discussed.
And anything
And
else?
defamation.
Yeah, defamation and also we have here only. Against property only, trespass only they discussed, right?
Yes, ma'am.
Okay, fine. So with regard to Unit 4, we will start. Okay, so what is given in Unit 4 from your college lectures? What do you remember? Trespass is there, defamation is there. What else do you have?
Trespass against person they have taken, ma'am.
Yeah, trespass against person also they have taken. Yes, right. So if you look at the, like the syllabus, right, for Unit 4, it is basically having like two different things. All right. So if we see here, right, I will just minimize this thing. So there are basically like two different things. Okay. One is torts against property and other one is torts against person. So what is tort we know, right? It's like a civil wrong, right? When some slight harm is being caused where the entire society will not be affected, but maybe you, your family members or your relatives will be affected, right? It's like a lesser harm that is being caused, which is like a wrong, right? We should not be doing it. So when we say this tort, right, there are basically two different types of torts that are given in your Unit 4. One is which is against property. So against property, if you study other law subjects like IPC and all, right, when we say property, it may include a lot of things. All right, it may include your mobile phone, it may include your house, land, it may include some other rights, it may include a lot of things. All right, but with regard to torts, it is basically, like it's not like you cannot like trespass my phone, right? What you can do, maybe you can enter my property without my permission, but you cannot trespass my phone really, right? If someone takes my phone without my knowledge, without my permission, it would be a crime, right? It will be theft. There are so many other different crimes. So when we say property, it usually includes like a plot of land or might be a house, like as discussed in your college also, that torts against property, what it may be, that someone is entering your premises without your permission or without your invitation, right? That may be included. And tort may be against person also. Against person, when we say, right, if a tort is committed against you, it may affect you in 4 different ways. All right, so you need to remember that tort against property, it's usually the trespass only which we have. But when we say tort against person, it may affect you in 4 different ways. All right, what are these 4 different ways? It may affect your body. All right, it may affect your reputation. whatever reputation you have in amongst your might be friends, relatives, and other known people, right? It may affect that. It may affect your freedom, right? You are free to do whatever you want. You are free to go wherever you want, right? But that freedom may be taken away, or it might affect some other rights that you have. Okay, it might not be affecting your body, reputation, or freedom as such, but some other rights. It might be some domestic rights, some contractual rights and stuff that are being affected. All right, so when we say Unit 4, it is basically covering these things: tort against property or torts against person. Both the two things are included. When we say tort against person, it will affect the person's body, reputation, freedom, or some other rights. Okay, it may be some domestic rights, contractual rights, or some other legal rights that are being given to the person. Okay, this part is clear, right?
Yes, ma'am.
So domestic rights, do you remember what all things are included there from your class maybe? What is domestic right? Any point you remember? Like you remember like defamation, you remember, right? For reputation, it's defamation. For domestic rights, what all we have? So see, these are the things which we have, right? First one I told you, tort against proper person. And second one is tort against property. For property, we don't have any such like subdivision and stuff. But for tort against person, we have 4 things: body, reputation, freedom, domestic, or some other rights which are there. Right? So when we say tort again affecting body, right, what is it? Your body might be affected. How it may be affected? There are basically 4 things: assault, battery, mayhem, and false imprisonment. All right, today we are going to discuss these 3 things. Why only these 3 things? Because these 3 things are related to one another, but false imprisonment is like slightly different. Okay, so today we are going to discuss these 3 things which are nothing but tort affecting body. Okay, and these are torts against person. Specifically, it will affect body of the person. So like whatever question you get, right, from Unit 4, like last year, I remember in 2019, there was a question like write a short note on assault. Right, so when you get such kind of a question, obviously you need to explain on that question, right? So what you can do is you can write a bit of intro on what trespass is, right? It may be affecting the person or affecting the property of the person also, right? And then whatever they are mentioning, if it's defamation, you can write something with regard to reputation. If it is freedom, you can write something with regard to freedom. Like that also you can explain on it. All right, so this is like a basic intro which you can give on anything, right? It does not matter what the question is. From Unit 4, whatever is the question, you can write this intro. After that, you can explain with regard to what is it affecting, right? If they are asking, write the short note on defamation, you can write with regard to tort affecting reputation, and similarly. Okay, so what is this intro we have? Trespass to person is a tort which is frequently committed in everyday life. It is basically unreasonable interference. All right, unreasonable interference with body of a person which can be committed either by causing actual harm or by just causing an apprehension of force. That means tort to person is like a very common thing that we keep seeing in our everyday life, right? These kind of things being committed. What is it? It is basically unreasonable interference. What is unreasonable? That means you are not justified in inflicting that harm on me, right? You do not have a valid justification like we have in case of general defenses we saw, right? Self-defense and stuff we had. Like that, you don't have any justification here, okay? Unreasonable interference with body of a person, which can be committed either by causing actual harm or by just causing apprehension of force. That means when you cause this harm, maybe you have actually caused some harm, right? Actually, this person got injured or something, or it might be just an apprehension. Okay, what is apprehension basically? Sometimes like we apprehend things, right? Like we may be like, okay, fine, maybe in September we will have our exams, right? What is it? You have not yet received the notification, but still you have an apprehension that might be in September my exams are going to start, so I need to study. So what is that? You have this thing, right? That there is a likelihood or there is a possibility that my exams will start, right? Similarly, we may feel like, okay, fine, might be there may be like a surprise test in class, right? What is it? You don't know whether teacher is going to conduct a surprise test or not, but we just have that apprehension, right? We feel like, okay, fine, this might happen, right? So that is apprehension. Same apprehension may apply here also. What they are saying, it may be that actual harm is caused to the person, right? Like maybe slapping a person, right? So slapping is what? Actual harm is there, right? Actual hurt is there, but it might be just an apprehension of the offense, right? If someone is like very angry, okay, like might be two people are fighting, okay, I'm fighting with one of my friends and I'm so angry that I'm like, I'll slap you someday. When the moment I do like this, what is it? There is an apprehension that I may slap the person also, right? So that also may be included. Okay, so both these two things will be considered as a tort, right? Actually slapping a person or just, like creating this thing that I'll slap you someday. This, like this gesture is also a tort, which we have affecting body. Why? Because it also creates a reasonable apprehension, right? The other person who think that, oh God, might be she is going to slap, right? So that also will be included here. Okay, both these things will be considered as tort affecting person, right? Against a person's body. Tort against person may affect body, reputation, freedom, domestic or other contractual rights, like we have seen here, right? It may be divided into different types based on what is it that it is affecting. So first of all, we have torts against body, right? Whereby body of a certain person is being affected. Okay, so what is it? Tort affecting body of a person may be committed by way of assault, battery, mayhem, or false imprisonment. What is assault first of all? These three things, right? Assault, battery, and mayhem, they are like, like three different stages of something. Okay, it's like very slight thing and then causing it and then aggravated form of it. All right, so what is assault, battery, and mayhem? Anything you remember from these 3 points? This, right? Affecting body, assault, battery, or mayhem. Do you remember something from your class?
Assault means like a threatening.
Your voice is breaking. Hello? Yeah. Am I audible? Your voice is breaking because. So assault, battery, and mayhem. Okay, first of all, assault. What is assault? Assault is an act of defending. Network issue. Okay, I am audible, right? Or my voice is also breaking for you? Okay. So what is assault? Assault is an act of defendant Who is defendant? There are two parties in a case, right? Plaintiff is the victim who goes to court, files a case, and defendant is the person who is accused of doing something wrong. Assault is an act of defendant which causes reasonable apprehension of the infliction of battery on the plaintiff. That means, like I said, right, if I just tell my friend that, okay, I'll just slap you. The moment I do like this, it creates an apprehension, right? It creates an apprehension of infliction of battery on the person. The other person will apprehend that maybe I'm going to cause harm to the person, right? So that is assault. That means just until I, like hit the person, actually, that is assault. Till that moment, it is assault. When the defendant, by his act, creates an apprehension in the mind of the plaintiff that he is going to commit battery against the plaintiff, the wrong of assault is completed. That means until I touch this person, or I cause the harm, or I commit this offense, like wrong of battery, it will be considered as assault. Okay, so the moment I say I'll slap you, until this moment, until I slap the person in reality, that will be assault, because it is creating an apprehension in mind of this other person that I may cause hurt to the person. All right. The wrong consists of an attempt to do the harm rather than the harm being caused thereby. That means until I slap the person, I'm not causing harm, right? But what happens is there is like an attempt, right? Because I'm just creating that posture, right? I'll just slap you. That means until that moment, it is just creating like an apprehension in mind of the other person that there may be infliction of hurt for the other one. All right. Pointing a loaded pistol at another is an assault, because the moment I point a loaded pistol, the other person is going to apprehend the risk, right? So that also will be assault. But what if the pistol is not loaded? Okay, not loaded. Pistol is not loaded, but still I'm pointing it to another person in such a distance that if it was loaded, it will kill the person. In that case also, it would be considered as assault until and unless the other person know that this pistol is not loaded, right? Because otherwise, if you do not know whether this pistol is loaded or not, and I'm pointing the pistol at you, obviously you are going to apprehend the risk, right? Because you do not know whether it's loaded or not. Like we have seen so many these cases where, like robbers would come and with might be like a toy pistol also, they would try to, like point it to person, and people would think that it's a real pistol and they would just hand over whatever they have, right? Or might be it's like an unloaded pistol, but still they would pretend as if like it's loaded, and people would also believe on that. Why? Because we never know whether it's loaded or not. If not, fine. If loaded, we may die the next moment itself, right? So it anyways is going to create apprehension in our mind. So if it is unloaded also, and the other person do not know whether it's loaded or not, in that case also we will say that there is assault. But if the plaintiff knows that the pistol is unloaded, there is no assault, because if it's unloaded, definitely it cannot kill you, right? It cannot cause you any harm. So in that case, it's not reasonable for you to apprehend any sort of risk. All right, so this is what assault is. Generally, assault precedes battery. So the moment I slap this person, it becomes battery, and until I slap this person, whatever I'm doing, that is assault, right? So assault is like the first step of battery, when I'm just telling the person that someday I'll slap you, right? So that is what that assault precedes battery. Assault will come, and after that battery will come. All right, throwing of water upon a person is an assault, right? Throwing of water upon a person is an assault. Or if you split coffee or some tea or water, whatever it is, that will be assault until the moment this water, coffee or tea, it falls on the other person. All right, it becomes battery. So the moment it touches this other person's face or body or whatever, it will be considered as battery. Just before that, whatever is the time, it will be considered as assault. All right. If a person is about to sit on a chair and the chair is pulled, this is something that we used to come very, like frequently do as a child, right? Someone is trying to sit, we will pull the chair or bench or whatever it is, and the person would fall, we all will laugh, right? Because at that point in time, we did not know that it's a tort, but now we know that even that is a tort, right? So the moment we pull this chair and this person is about to fall, it is assault. But the moment his body touches the ground, because he falls, that will become battery. All right. So assault is just the previous step of committing battery. Okay, where there is just apprehension, because when this person is about to fall, might be someone would come and hold him also, right? So until he falls, that would be considered as assault. The moment he falls, it would be considered as battery, right? So if I pull the chair, this person was about to fall and someone caught him, I will be held liable for this battery only, right? Because this person, like assault only, because battery was not committed there. So there is assault as long as he is in the process of falling on the ground. But as soon as his body touches the floor, it will become battery. All right. Is this part clear?
Yes, ma'am.
So it is, however, not essential that every battery should include assault. It's not, even if we are saying that assault is like the first step and then there will be battery, it's not necessary that in every single case it has to be in that order only, right? Sometimes there might not be assault directly, there might be battery also. How? Might be if someone is trying to hit another person from back, right? So obviously he is coming and trying to hit and stuff, but this person is not knowing, right, that someone is coming to hit me and stuff. He will come to know the moment he is being hit, right? So in that case, we can say that there was no assault directly. This person had caused harm to the other person, right? So in general, there is like assault and then battery, but in some cases like hitting someone from the back and stuff, assault might not be there directly, it may result in battery also. All right. So there was this case with regard to assault wherein the plaintiff was the chairman of a parish meeting and the defendant was also seated in the same table. So there was some meeting going on and people were seated in a table. During the proceedings, while they were discussing on the meeting and stuff, the defendant became angry and interrupted the meeting, right? He was so angry that he wanted to stop the meeting in between. During the proceedings, the defendant became angry and interrupted the meeting. The other members voted to expel him from the meeting, right? Because he was angry, he was trying to interrupt the meeting. Other people said that we should expel this person. We should, like ask him to move out from here. The defendant advanced upon the chairperson to hit him, but was stopped. The defendant was held liable for assault. That means because he was angry with the chairperson and he was asked to leave the room, right? He was so angry that he was about to hit the chairperson. But because there were other people around, everyone stopped him and he could not actually cause harm to the chairperson. Right. So in this case, it was said that he is guilty or he is liable of the wrong of assault. Why? Because he tried to cause hurt, right? There was like apprehension that he would just cause harm to the chairperson, but he actually could not do it because he was stopped by other persons, right? So that is assault, like the moment just before you like actually cause the harm or hurt. Right, there is another person. If a person is about to sit on a chair and the chair is pulled, there is an assault as long as he takes to fall on the ground. The moment he makes contact with the ground, it becomes battery. Like I said, if someone is trying to sit, you pull the chair, this person will, like about to fall. So this about to stage will be assault. The moment he falls, it will become battery, right? So these two cases also you can write if there is a question on assault. Okay, is it clear?
Yes, ma'am.
So assault, we know, right, that it is just until the moment when you are just apprehending that might be this person may cause me hurt or loss or harm or stuff. But what is battery now? The wrong of battery consists in intentional application of force. So here there is no apprehension, but here there is application of force to another person without any lawful justification. That means here the person is not apprehending, but rather you are actually causing him hurt or loss. Right? So what are the essentials? There are basically two essentials that we need for the wrong of battery. All right, what are these essentials? First of all, there should be use of force. That means you are using force on the other person to affect his body, right? Secondly, the same should be. That means this use of force should be without any lawful justification. That means you should not have a justification like we say in case of general defenses, right? That if it is like self-defense or if it is like statutory authority and stuff, it is not included, right? So those defenses should not be available with you. Okay, so there are these two essentials with regard to battery. First one is use of force. So what is use of force? Even though the force used is very trivial and does not cause any harm, the wrong is still constituted. That means we are not concerned with how much of force you are using, but rather we are concerned with the fact that you have used force, right? You have inflicted some hurt or harm to the person. So even if it's like very small, trivial in nature, right? It is something which does not cause such hurt in reality, but still it would be considered. Right? Because might be you are, like, okay, fine, I'll slap you, and then you're slapping very, like gently. In that case also, it would be considered that yes, you have slapped the person. Whether it's, like very gently or what, that does not matter, right? So even though this force is very trivial, very small, it does not cause any harm. Even in that case, we would say that this offense of battery is being committed. Physical hurt need not be there. It does not need that, okay, fine, like this, it's paining, it was so hard and stuff. That is not needed, but just causing something is also like important, right? That you are, like you are basically using force. That is only important. Least touching of another in anger is a battery, right? You might be just, like pushing a person or something. Like least touching might be with a finger also, you are just pushing a person or something. That may also amount to battery if this touch is in anger, right? So that would be considered. The force may be used even without a bodily contact with the aggressor. It does not need that your body is touching this other person's body. Okay, without touching this person also, you may be guilty of committing this offense of battery. How? Without touching a person, how can you cause harm to the person? Might be the force may be used even without bodily contact, like using a stick, bullet, or throwing water, or spitting on a man's face, or making a person fall by pulling his chair are examples of force. Right? If you are not touching this person, but you simply pull the chair, that is also something. Spitting on a person's face, throwing water, or might be like using a stick, pointing a pistol, all that stuff also would be considered here. All right. Infliction of heat, light, electricity, gas, odor, etc. may also be considered as battery if it is resulting in physical injury or personal discomfort to the plaintiff. All right, those also will be considered as battery. So this is what is use of force. Even if it's very small, very trivial, does not matter, that also will be considered. All right, and when we say use of force, It's not necessary that there has to be like one person touching the other person. It might be without having any body contact also, that by pulling a chair, by, you know, like using a stick and stuff also, it might be done. So this is use of force. Mere passive obstruction, however, cannot be considered as use of force. So there was this case wherein a policeman unlawfully prevented the plaintiff from entering the club premises. It was held that policeman was entirely passive, like a door or wall put to prevent the person entering the room. So policeman was basically under some sort of mistake of fact, and on that mistaken belief, he stopped this plaintiff from entering a club. Right? In that case, it was said that no, this policeman is not trying to push this person or something. He's just standing like in front of the gate like a wall, and he's not allowing or, you know, like making space for this person to enter the club. So that would not amount to assault basically. All right. So this is first one, use of force, which how it can be used basically. You need to know that. Is it clear, use of force?
Yes, ma'am. Ma'am, in order means what, ma'am? In
Which
light
one?
of light electricity gas.
Yeah.
That order means.
Okay, sorry. Not order. Has to be order. All right. Spelling mistake. Okay, so it might be by inflicting heat, light, electricity, gas, odor, etc., which are also creating some personal discomfort or some injury and stuff. Okay, so this is use of force, which is like the first essential that we have with regard to battery. Second one is without lawful justification. That means, yes, you are using force, right? There is use of force, but this use of force is without lawful justification. All right. So what is without lawful justification? It is essential that the use of force should be intentional and without any lawful justification. Right? That means you are intentionally using force, that too without having a valid justification. Harm voluntarily suffered is not battery. If you are yourself coming to me and saying that I want, might be like some piercing and stuff, I want to get a piercing done, there you are voluntarily coming forward. Like we have seen these defenses, right? Voluntary non-fit injuria. Voluntarily, if you are coming forward, might be to get a tattoo done or piercing and stuff, that will not be considered. So harm voluntarily suffered is no battery. The use of force may be justified in pulling a drowning man out of water. If someone do not know how to swim, this person is drowning and another one comes and pulls him with his hair just to save that person's life. In that case also, we will say that this is not battery. Even if there is no consent of the person, voluntarily that person is not doing also, but even in such a case, it would be considered that it is not battery. Forcibly feeding a hunger striking prisoner to save that person's life, right? That also will be considered as, like that also is not like unlawful. There is also like a justification in order to save the person's life only. There is force feeding of a hunger striking prisoner. Or performance of operation of an unconscious person by a competent surgeon to save the person's life. If someone is unconscious, the person needs to get some operations done. We see, right, that surgeon would take consent from the, like the attendant or relatives of the person and get the operation done. That also will not be considered as battery, because all these things are done to save like a person's life. Okay, so this is what without lawful justification is. But in these cases, we do have a valid justification of saving life of a person. All right, then we have these cases, which, see, these cases, right, you can try to remember them, because in question, right, that they might ask you with regard to one thing only, right? Write about assault, write about battery. So in that case, you need to have enough of things to write. All right, so you can remember like 2-3 cases for these things. So with regard to battery, we have this case where the forced feeding of a hunger striking prisoner to save his life was held a valid defense for battery. An injury that is caused unintentionally or by accident is not considered as battery. All right, so those cases are because justified. You are doing it in order to save a person's life only, so it will not be considered. So there is this lady from Manipur. Are you aware of her? Iram Sharmila. She was on hunger strike for like so many years, right? Have you seen her? She was like on hunger strike because she was against one legislation, like one law which is there applicable. Okay, Armed Forces Special Powers Act. You will be studying that legislation some year in your LLB. So basically she said that until and unless this legislation is abolished, I am not going to eat anything. Okay, I will die like with something inserted in her nose. She will just take some like liquids, not like solid food or anything. Okay, she will not eat anything with her mouth. So she was arrested many times and stuff. Okay, so those are examples of like hunger striking prisoner. That means I am striking, but it is like hunger strike. I will not eat anything unless and until my demand is fulfilled. All right, so in such cases, someone may forcefully feed the person to save that person's life. That will not be considered as like illegal or unjustified. All right, similarly, there is another case wherein it was held that fixing a live electric wire without due warning to keep passengers away and causing death of such trespasser was actionable. That means if you are fixing something and there is some risk, you usually might be like block the road or put in some signboard so that people do not come close to it, because there might be some risk involved in it. If you fail to do it, then in such a case, it might be said that this person is guilty of battery. Okay, similarly, we have this another case wherein a person was traveling in a train without having like a valid ticket. Okay, then he tried to purchase a ticket, he did not get it, and then in some other station, right, they asked that, okay, fine, show the ticket, and then he was not having any tickets to travel, and the person said that, okay, you just, like get down from the train because you are not having a valid ticket. The person was not doing it, so force was used to, like throw him out of the train. In that case also, it was said that it's justified because you should not be traveling without a valid ticket. If you are doing it, you are like a trespasser, and with regard to trespasser, we can use some reasonable force to throw him out of the premises, right? So in case you are traveling in a train without a valid ticket, you are also no less than like a trespasser. And accordingly, reasonable amount of force may be used in order to throw that person out also. So this is a case where it was said that it is justified if he was thrown out of the train. All right, so this is what we have with regard to battery. There are two essentials which we need to satisfy. First of all, use of force, and secondly, it should be like without a valid or lawful justification. Is it clear?
Yes, ma'am.
So what is assault? That you are just creating like an apprehension. There is no actual, like force used or harm caused to the person. But in case of battery, you are using force without a lawful justification, and you are, like you are committing this crime, whether there is lot of harm caused, no harm caused whatsoever it is, you are basically using force. So that itself will make you answerable under this wrong, right? Third one that we have is mayhem. What is mayhem? It is like an aggravated form of battery. That means more serious version of battery. right? If assault is here, battery is here, mayhem would be somewhere here. All right, these are like three different, like stages of it. What is mayhem? Voluntarily depriving another person of a body part to render less effective that person's defense of self. That means we have this self-defense, right? If someone is trying to hit me, I can use my hands, I can use my legs, I can use my mind to defend myself. All right. If this person is causing such a amount of force that I can't move my hands, that means what? I would have otherwise defended myself by using my hands, right? But because this person had hit me so hard that I cannot move my hands, and because of that I am not able to defend myself, in that case it would be considered as mayhem. So mayhem is like an aggravated form, more serious form of battery, wherein some body part of the person is made incapable of use, basically, right? Such a serious amount of force is being used. Mayhem deals with the disfigurement or loss of any body part due to physical injury caused by the tortfeasor. When we say loss, it does not mean like chopping off the hand or something like that. Might be it was injured so bad that for the moment I cannot move my hand, right? That also would be like like loss of a body part. For the moment I was not able to move my hand and defend myself, right? It might be some sort of disfigurement also. It basically is like a serious form of battery, all right, wherein some part of the body is is something that I cannot move or I cannot use to defend myself, like disabling of an arm, hand, finger, leg, foot, or eye are examples of mayhem. Okay, so there was this case wherein like a plaintiff had recovered damage from the defendant for the action of battery. That means for inflicting harm to the person without a lawful justification, he had already got compensation for the offense of battery. But slightly after some time, part of his skull by reason of the said battery came out of his head. All right, and in this case, it was said that because it is, like making something like unfit or like disfiguring or loss of like a body part, so this person and again got compensation with regard to mayhem. All right, so mayhem is like a serious or an aggravated form, wherein in this case it was said that yes, loss of skull also would be included here. All right, will also be included as mayhem. There was another case wherein it was held that a queryman had a cause of action against the defendant who had caused plaintiff's customers to discontinue buying the queried stone by threatening them with mayhem. That means one person was, like digging out some stones and valuable stuff from soil, and his customers, whoever were his customers, another person warned those customers that if you buy stones from this person, I will commit this wrong of mayhem. And based on that threat only, those customers stopped buying those stones from the person, right? So in this case also, he filed a case and accordingly it was held that yes, it is like mayhem basically, right? Because he is threatening those persons with regard to it. So is this part clear? Three different torts which we have: assault, battery, mayhem. Is it clear? So then we have this small thing with regard to the differences. All right. So the basic difference between assault, battery, and mayhem has been established above. By studying all these three different things, we have understood how they are different from one another. Right. So assault is an action that causes an apprehension in mind of the victim that an act of battery is about to take place. Until the moment I tell my friend that I'll slap you, until that moment, my friend will only apprehend that I may slap her and there may be this wrong of battery which may be committed, right? So in case of assault, it is until battery is committed, like pulling a chair until this person falls on ground, it will be assault, right? So battery, what is battery? Battery refers to the act of striking or striking someone with physical force and no lawful justification. You are hitting someone, you are using force against someone, that too without having a valid or lawful justification. All right, then third one, mayhem. What is mayhem? Mayhem refers to the act of crippling someone or rendering them defenseless. You are causing such a serious amount of force that this person, some part of his body is like disfigured or made ineffective in defending the person himself, right? It's like an aggravated form of battery. Assault generally refers to only intent to cause harm. I'm not yet causing harm. I just have this intention of slapping my friend. Whereas both battery as well as mayhem inflict physical injury upon the victim. In one case, it might be very small. In another case, it might be very serious, right? So battery and mayhem are based on the amount of force that I am using. But with regard to assault, it is just an intention of causing harm. I have not yet caused the harm, right? Assault takes before the crime of battery is committed, and mayhem is a severe form of battery. All these three torts are associated with one another. These three torts are associated with one another. First one is just the intention. Second one is might be very slight, unlawful force used. Third one is it might be very serious, leading to disfigurement or making some body part unable to defend the person, right? So then you can give like a conclusion that does the term assault, battery, and mayhem appear to be similar? In all the cases, it's like kind of similar only, right? Against the person, some force is being used. But they are quite often interchangeably used, but they are different in terms of their meaning. And so we should not be like, we should be understanding how they differ from one another, right? So these are the three different types of crime or like wrongs which may be committed, which may affect body of the person, right? One more we have with regard to false imprisonment, which is a little different. So, okay. So what is imprisonment? Have you come across this word previously, imprisonment? Have you seen this word somewhere?
Hello, ma'am.
Imprisonment, have you seen this word somewhere? Sometimes have you come across it?
Yes, ma'am.
So what is imprisonment?
Without by false information, we are impressing someone, ma'am.
Imprisonment in general would mean sending someone behind bars, right? If someone commits a crime, we say that this person has committed this crime. So maximum punishment, maybe he will be sent, he will be given imprisonment up to maybe 3 years, 6 years, like that we say, right? So imprisonment means sending someone behind bars, restricting persons like movement, right? He cannot freely go anywhere he wants, but he is basically restricted within a certain premises. That is imprisonment. But what is false imprisonment now? Sometimes, even if a person is restricted, he is not allowed to go wherever he wants, it may be justified, right? If a person commits a wrong, he commits a crime, he harms someone, he kills someone, it is justified to keep this person restricted. But there may be some cases wherein it is not justified. You do not have valid grounds to arrest that person. You do not have valid reasons or powers to arrest that person. In such cases, we will call it as false imprisonment. Okay, so what is false imprisonment? It is when we say false, right, that means you do not have valid enough reasons or you do not have power to arrest that person, but still falsely, wrongfully, you are arresting someone, right? That is nothing but false imprisonment. So false imprisonment is an act punishable under criminal law as well as under law of torts. There are different types of crimes which may fall under criminal law also, it may fall under civil law also. Same applies for false imprisonment. We have it as a crime under criminal law also, we have it as a wrong under law of torts as well. Under law of torts, it is classified as intentional tort. A person commits false imprisonment when he commits an act of restraint on another person which confines that person in a bounded area. There are basically two types of restrictions. Okay, that is wrongful restraint and another one is false imprisonment. When I say wrongful restraint, restraint means what? Restriction. That means you are restricted from entering somewhere or going in a certain direction. But this restriction is only towards a certain way. You are otherwise free to go wherever you want, you can go, but only there is like a restriction with regard to this way or this road. That is nothing but wrongful restraint. You are being restricted from entering in a certain premises. If it is my house, I can definitely restrict you because it's a private property. But if it is like a public field or like a public road and I'm restricting you that you cannot enter this road, you cannot use this road. But otherwise you are free. Wherever you want to go, whatever you want to do, you do it. Just that you cannot access this road. That is nothing but wrongful restraint. You are being restricted from accessing this road. Okay, that is very different from false imprisonment. What is imprisonment? You are restricted or you are confined within like four walls of something. Might be you are confined in a jail, confined inside a small room, confined inside a very big room, confined inside a house, confined inside a very big building. Whatsoever it is, you are basically restricted. Your movement is restricted. You cannot go out of this building. All right, that is nothing but false imprisonment. Wrongfully, without having any valid grounds, without having the power or authority, I am restricting you from going out of this house or building or a certain room also. Okay, that is nothing but false imprisonment. Do you remember when this special status of Jammu and Kashmir was removed? Do you remember that time seeing in news that all the political leaders?
Yes, ma'am. Article 371.
Yeah, article
371.
370. Article 370 was removed, and then what happened is all those political leaders and all, they were under house arrest, right? Do you remember that? They were not allowed to go out, meet
Yes,
other people, right? So what was that? They were restricted inside their house, right? That also is like confining them, but that was with a valid reason because government did it with lawful authority. That is not false imprisonment. But if it was without lawful justification, if 370 was like that only, but still they just said that, okay, all the political leaders, you cannot come out of your house. You will be house arrested. In that case, it would have been a case of false imprisonment, that they are being restricted or confined within this premises, restricted within this premises. Okay, so what is false imprisonment? It may come as a crime under criminal law. It may be a wrong under civil law, that is law of torts as well. When we say false imprisonment, when he commits an act of restraint on another person which confines that person in a bounded area. This bounded area may be a very small room, very big room, a house, a building, whatsoever. Okay, that is false imprisonment. To constitute this wrong, imprisonment in the ordinary sense is not required. When a person is deprived of his personal liberty, whether by being confined within the four walls or by being prevented from leaving the place where he is, it is false imprisonment. Otherwise, in general, when we hear this term imprisonment, what do we understand? We understand sending someone behind bars. Behind bars as in there would be like jail, this bars would be there, right? This person would be sitting behind it and he is restricted. That is the usual thing that we think of when we hear this term imprisonment. But it need not be that sort of a setup. We don't need like bars in reality that a person is sent behind bars, but he may be even, like restricted inside a very nice, all the facilities are there, proper house also he may be restricted. That also would amount to false imprisonment, even though that is that person's house only, that person's office only, does not matter. It also would amount to false imprisonment because they are confined in a certain limited area. If a man is restricted by a threat of force from leaving his own house or an open field, there is also false imprisonment. If it is like a very big field, it's an open field like this Lal Bagh. Have you visited Lal Bagh? Lal Bagh, have you visited Lal Bagh? That garden is there, right, in Bangalore?
No.
You have not visited. Okay, so that is like a very big garden. You cannot like walk and like visit this entire place. It's so big. Okay, it's like an open place, open garden, public garden. There also, if someone is restricted, if someone says that okay, this is Lal Bagh, you cannot come out of it. In that case also, that would amount to false imprisonment, even if it's like a open like field or it's that person's own house, because you are being restricted. You cannot come out of this park, or you cannot come out of his house. That also would amount to false imprisonment. Then we have some elements of false imprisonment. What will constitute false imprisonment? First of all, period of confinement. That means the duration for which a person was confined, a person was restricted in a certain area. The tort of false imprisonment arises whatever may be the period of confinement. We are not concerned with this duration for which the person was confined. It will still be applicable. Okay, so it does not matter if the person was confined for 5 minutes, if the person was confined for 5 days, 5 months, does not matter. Depending on time frame, we cannot say that, yeah, this time frame is something where you can approach the court. You can anyways approach the court if there was wrongful, like false imprisonment. Okay, but why is this period of confinement important? When is this time frame important? It is important when we are deciding the compensation to be paid, right? Because if you were being restricted for 5 minutes, maybe you would not mind that, right? You would feel that, okay, fine, I have anyways not visited Lal Bagh, so let me visit it. Let me enjoy the park. You may even not mind if you are confined there for 3 years, because that much of time you would anyways need to see the place, right? So even if it is like 3 hours, maybe you would not mind and you would feel that, okay, fine, let me explore the place. But that also would be counted. Whatever is the time frame, it's a wrong, means it's a wrong. But time frame will be important at the time of deciding the compensation. Because if someone is restricted for 5 minutes, I would not mind. But if I'm restricted for 5 days, it will affect me mentally. If I'm being restricted for 5 months, it is going to have like a major impact on me. Okay, so while deciding compensation, they will take into consideration this duration as well, because longer the duration, longer will be the sufferings of the person, right? So period of confinement is not like a ground which should decide if you have a right to approach court or not. You anyways have that right, but this period of confinement or the time frame will help courts decide what would be the right amount of compensation to be paid to the parties, right? And otherwise, lawful detention may become unlawful if the detention is prolonged for an unreasonable time frame. Also, why is time frame important? Because sometimes it may be lawful imprisonment also. I have done something wrong and accordingly police caught me. I should have been in jail for might be like 24 hours. Okay, 24 hours is like the maximum time frame for which I should have been in jail. But police kept me inside for 2 years or 2 months. In that case, what happens? Earlier, initially, it was lawful, lawful imprisonment only, right? Police officers were having the authority to arrest me, keep me confined and stuff. But just because they exceeded this duration, in place of 24 hours, they kept me there for 2 years. Just because of this extended time frame, it becomes unlawful. This later part, right? This later period becomes unlawful. Okay, so that is the reason why this period of confinement or time frame of confinement becomes important. Is this part clear?
Yes, ma'am.
Next one is willful detention. False imprisonment or restraint must be intentional or willful. Accidentally closing the door when someone is on the other side is not wrongful confinement or false imprisonment. Willful detention applies to intentional restraint in any form, including physically restraining a person from exiting, physically locking him in a building, room, or from other places, and restraining him from leaving through force or intimidation. So it has to be willful detention. Willfully, intentionally, I should be restricting a person. Okay, sometimes it may happen that by mistake, we did not know that someone is inside the house and we just locked the house and went out. In such cases, that will not be false imprisonment because we were not even having the knowledge that someone is inside the house. Okay, so in such cases, it will not be false imprisonment, but it will be false imprisonment when I'm knowingly doing it. Okay, so there was one, when we were in school, right, there used to be one chapter in our English textbook where it was like, during the summer holidays, right, before the holiday is declared, you will have one class. Where you having such classes in your school? Before your summer vacation, they will have one class where they will tell you these are your homeworks, you need to complete all that stuff.
Yes, ma'am.
You had, right? So that class is not like your usual duration. Usually it gets over in 2-3 hours, right?
Yes, ma'am.
Yeah, so what happened, right? That was like a story, okay? That said, okay, fine, there was this summer holiday was to be announced in a certain school. So there was one student, he also went like very excited. He also went to school and then he went to the washroom. Okay, so when he was inside the washroom, like after school, like school homework and everything was given, school was like closed. So before leaving, he went to the washroom. And then when he was inside, right, this security guard, he was like locking the school, entire school building, everything he locked. And then he just came and locked the washroom also from outside and he left. So the student was like inside the washroom and he was like trying to open it, trying to shout, but everyone already left. So something happened after that, like he was there for, I think, few weeks or something. Right? So those cases will not fall under false imprisonment because even if the person had suffered, it was like unknowingly that the security guard just came and locked him from outside. Right? So this is very essential that it has to be willful detention. Willfully, I am confining a person. It may mean I have locked the person from outside, or it may simply mean it's like an open house or open field. But I have said, you cannot come out of this field. If you do, I will kill you, I will beat you, I will do whatever. Right? In such cases also, it would be wrongful confinement, even if I'm not locking the park from outside or something. But I have said him that, okay, if you come out, I'm going to harm you. In that case also, that will be wrongful, like imprisonment, right? False imprisonment. So first of all, period is not important for what duration person is confined, but it will be important or relevant once we decide the amount of compensation to be paid. And sometimes lawful imprisonment may also become unlawful if this duration is prolonged, right? If a person exceeds that duration. Second one is willful detention. It has to be willfully done. By mistake, if something happens, that we can like get the excuse. We have seen, right, these general defenses also. By mistake, we are doing something. So those things would fall under here as well. Last one is unlawful detention. In order to constitute the wrong of false imprisonment, it is necessary that the restraint should be unlawful or without any justification. For example, if a person is not released from jail after his acquittal, but is continued to be detained thereafter, the detention can be considered as unlawful. What is acquittal? Acquittal and conviction. We have two words. Are you aware of this?
There will be like a PDF for.
What is it? Acquittal and conviction?
Don't know, ma'am.
See, when a person, take for example, I feel that this person has killed another one. Okay, I went to court and I said that B, he has murdered C. Okay, I went to court, filed a case against B saying that B has murdered C. In that case, it's just a statement that I'm making. Court is not yet sure, right, whether B has actually killed C or not. So court is going to decide the case based on evidences available, based on whatever witnesses had to say, all the other things. Court is going to decide the matter finally. So when I say that B has killed C, my statement may be true or false. My statement may be proved in the court or not proved. Okay, so based on that statement, right, court would finally give a judgment. In that judgment, court will either acquit the person or convict him. Conviction means court also accepted that yes, this person is guilty, this person only killed C. That is conviction. And based on the conviction, court will give him punishment also. Court is going to give him punishment. So conviction means the person is proved guilty. What is acquittal? Acquittal means that this person is released, not proved guilty. Okay, this means this person is not proved guilty. I could not establish his fault and the person is accordingly released by court. Okay, so these are two words, acquittal and conviction. So what is it said here? For example, okay, so unlawful detention. So it has to be unlawful detention. Sometimes maybe court has said, yes, this person has killed another. This person should be sent behind bars for like 10 years. Okay, in such cases, that is lawful imprisonment. That will be justified. But it has to be unlawful detention in order to constitute this wrong of false imprisonment. What is unlawful detention? That without having any valid justification, without having the power, someone is being restricted. Okay, for example, if a person is not released from jail, that means when a case is being filed for the purpose of investigation and other stuff, person will be in custody, right? Person will be taken in custody. Have you seen this recent case of this Shilpa Shetty's husband? Have you seen that her husband was arrested by police? Have you seen in news or something? No. Okay. Then Arnab Goswami, have you seen he was arrested? No? This year itself, starting? Journalist? No. Have you seen?
No.
So basically what happens, right? When a case is filed before court, or when an FIR is being lodged, right? At that time also a person may be arrested by police. Why the person will be arrested? Because there is a possibility that this person may try to escape. There is a possibility that this person may try to destroy evidences or try to, try to erase the evidences or try to intimidate the victims or witnesses and stuff. Okay, there are a lot of possibilities. That is why when a case is being filed, right, the person may be arrested by police. He will be kept in police custody for that duration. When the case is finally, take for example, a person is like that arrested and he was fighting his case, and finally one day court said that no, this person's guilt is not proved, so you need to release this person. Basically, this person is being acquitted from the charges. His charges were not proved. In such cases, that person has to be released. If court has said this person's wrong is not proved, this person should be released. But if he is not released, right? So if a person is not released from jail after his acquittal, once court concludes that this person's wrong is not established, release this person. After that also, if someone is not released but is continued to be detained thereafter, even after that the person is being detained, then in such a case we will say that this detention is unlawful. Initially it was valid when the case was going on and stuff, but once court concluded that this person's wrong is not established, release this person. After that also, if he is confined, we will say that it is unlawful detention. Okay, so these are the three essential elements which we need: period of confinement, willful detention, and unlawful detention. Is this part clear? Any point you want to be repeated?
Hello, ma'am.
Yeah, you got disconnected, right?
Yes, ma'am.
Yeah, I guess your voice is breaking now also. Fine, so these are the three essential elements which we have: period of confinement, willful detention, and unlawful detention. It has to be without any lawful justification that the person is being arrested. Okay, then we have defenses of false imprisonment. So these elements we would need to establish that it was false imprisonment only. But once you establish it that yes, there was false imprisonment, what all defenses will the person be having? What all defenses will the defendant be having to prove before court? All right, so we are going to see the defenses. So first of all, valid arrest. Like I said, right, sometimes arrest may be valid when the person has done something wrong, police officers are having the authority, court has passed an order. Okay, so in those cases, it would be said that no, we are having the power to arrest this person, plus there are sufficient reasons or grounds for arresting this person. It's a valid arrest, and so it is not false imprisonment. That is the first defense, which parties can use that yes, we are having valid reasons plus powers to arrest this person, and accordingly we have arrested him. Okay, first defense is valid arrest. Second is consent to restraint. A person who consents to be restrained or confined without the presence of fraud, coercion, misconduct cannot subsequently claim to be a victim of false imprisonment. Therefore, voluntary consent to false imprisonment is often a defense to false imprisonment. If, like we saw, right, voluntary non-fit injuria is a defense, same applies here, that if someone has given consent with regard to that restraint, that will not be lawful confinement, that will not be false imprisonment. Take, for example, if I'm sleeping at my house, okay, and there were just two people in my house, and the other person says that I want to go out, so why don't you lock the door from inside? I'm going out. Okay. And I was so lazy because I was sleeping. I was so lazy to go out and then lock the door. I said that, why don't you lock me from outside? Okay. You just lock me from outside and you go. Anyways, you are coming back up like in the evening. So you just lock me from outside and you go. I don't have to go anywhere. Anyways. Okay. In such case, if I have given the consent, okay, that I'm very lazy to go out, why don't you lock me from outside? In such a case, later on, I cannot file a case that it was like false imprisonment. I was being confined inside the house. Why? Because I only consented with regard to it, that you lock me from outside and then you go wherever you have to go. Okay, is it clear? Consent to restraint? Consent to restraint and valid arrest. Valid arrest as in it is a lawful justified arrest only. Consent to restraint as in I have given my consent with regard to it. Okay, next one is probable cause. When probable cause is established by the action, then false imprisonment and false arrest completely fail. It is stated that the probable cause test for imprisonment and arrest is an objective one. Sometimes imprisonment can be justified on the basis that defendant was acting in support of law. The blame for legal justification lies on the defendant. Sometimes what may happen is there may be a probable cause for arresting the person. Like police officer may arrest a person on the belief that maybe this person has committed a wrong. Maybe this person was causing some public nuisance, something he was doing wrong. Accordingly, based on that probable cause, police officers arrested a person. In that case, that also would be a defense that we thought that probably this person has done something wrong and we are having valid enough reasons to arrest this person. Okay, that will also be a defense. Is it clear, defense part?
Yes, ma'am.
Any point you want to be repeated from defense plus elements?
No, ma'am, it's clear.
So we have the elements, we have defenses, but now after defenses, if defendant was not able to establish any of these defenses, what all remedies do we have? Okay, so first remedy is action for loss. Damages in false imprisonment are those that flow from detention. So if I am being detained, I am being arrested, there is false imprisonment, I can file a case. There can be action for loss. I can file a case to get damages or compensation from the other person. Now, damages or compensation might be like the dependent on a lot of situations. Okay, there is no legal rule for assessment of damages and it is left to the courts only. We do not have, like we studied, right, in case of tort, damages are unliquidated. It is not prefixed. Only when case goes before court, court will decide. So in terms of false imprisonment also, we don't have any rule as such how we need to calculate the damages, or we don't have any defined figure also that this must be the amount of compensation, but it is left completely to the discretion of courts only. Court will decide what is the right amount to be given. The basis of damages includes injury and physical pain to the person, mental suffering, humiliation, loss of time, earnings, interruptions in occupation, decrease in medical expenses, injury to reputation, etc. It is not just that I am being arrested, it would also include a lot of things. Courts are also going to take into consideration that because I was arrested for 6 months, I could not go to my office, I could not do any work, I could not, maybe I was doing some course, I could not complete that course. It led to a lot of sufferings in my mind. it decreased my reputation. All those things will be taken care of, right? All those things court is going to consider, and after that, this amount will be decided, how much of compensation is to be paid. So first of all, action for loss, I can file a case in order to get compensation or damages for the loss which I have suffered. Secondly, nominal and compensatory damages. How much of damage is to be paid? There are two things. One is nominal damage, another one is compensatory damage. Nominal damage is like the minimum amount which is to be provided. Okay, in case it is like a very less duration, might be for 5 hours I was being arrested. In such cases, or maybe for 10 minutes I was arrested. In such cases, court will provide this nominal damage because I could not prove any other loss which I have suffered. Okay, if I was maybe arrested in Lal Bagh, okay, it was said you cannot just come out of this park, and I anyways like that like that park, so I was like, okay, fine, I will explore the place. If I was simply exploring the place, there was no loss as such to me, court would provide me this nominal damage, the minimum damage that court thinks is justified. But if I have suffered a lot of additional things, court is going to provide me compensatory damages. In order to compensate for all those different losses, court is going to ensure that I am being compensated. Take, for example, I was arrested for 5 days. And on those 5 days, I had like a very important exam for which I had applied. Might be application fee was some 10,000 rupees. Okay, so court is going to pay me that also because that money got wasted. I was preparing for that exam completely, but I could not appear for it. As a result, I would go through a lot of pain. Court is going to consider that also. For those 5 days, I could not go to work. There was loss in terms of earnings. Court is going to take into consideration. Because I was arrested, my family was concerned. Other people were like, okay, why is she arrested? Is she doing something wrong? All those things, right? All those things court is going to consider. And after that, court is going to provide me compensatory damage for all those things that I have suffered. Okay, so regarding damages, we have two things, nominal and compensatory damage, where what is to be applied, court will decide. We don't have any set rule for that. Okay. Next one is punitive, exemplary and aggravated losses. If the imprisonment has affected extortion, dishonor, libel, malicious manner, then in that case, court may go beyond compensation and court may even give punitive damages to the defendant as punishment. Some punishment may be given to the person. Punitive damages are being awarded in cases where conduct of defendant is grossly indifferent to the rights of others and knowingly or reasonably violated these rights. Intentionally, he did something very wrong. In such cases, court may also give him punishment. Okay, punitive punishments also might be given. Exemplary damages may be provided in certain cases when power is misused by the state. State had some power, they misused their power. The increased damage may be awarded in a reasonable case when imprisoning one is in a nominal character is offensive or plaintiff's feelings are hurt. Courts have often held that malice in the action of false imprisonment or false arrest will result in award of exemplary or punitive damages. That means additional amount may be said, right? Court may say that you have done such a big wrong that this small amount would mean nothing to you. So you need to pay a higher amount of compensation because your intentions were very bad. You intentionally caused a lot of harm to this person. Okay, accordingly, those things also court may take into consideration and court will accordingly decide the amount of compensation to be paid. Okay. Another thing which we have is self-help. If you are being arrested, you can use the reasonable power, like we studied private defense or self-defense, right? If someone is saying that, okay, fine, you just stay inside this park only, don't come out, you can simply push the person and run from there, right? That is nothing but self-help. You can use reasonable amount of force and try to escape from that given situation, and you can help yourself out by doing it. That is also available. Another one we have is habeas corpus. These are basically, we have a concept called writs. You will get this concept when you study Constitution of India. Okay, so what are writs? Basically, court will give some direction. Okay, it may be High Court or Supreme Court who will give some direction. In case a person is arrested also, writ of habeas corpus may be filed before Supreme Court or before High Court. Okay, Apex Court of India means Supreme Court. Under Article 32, we can approach Supreme Court, or under Article 226, we can approach High Court of the concerned state. And we can say that our arrest is not justified. Based on that, court will decide the matter, and court can say that, yes, this arrest is not justified, release this person. Or court may say that, no, it's justified only, so it is fine even if this person is arrested. Okay, so we have this provision of habeas corpus also, but it is like a criminal proceeding, okay, criminal writ. So in case of criminal cases, it will basically be used. So these are the defenses which we have. Is it clear?
Yes, ma'am.
Is it too much? We have 3 cases also. Is it too much, or we can discuss this?
Ma'am, that Beam Singh is the state of Jammu Kashmir, already discussed, I think, ma'am.
Okay. Oh, like in your college, it's already discussed.
Yes, ma'am.
Okay. All right. So then we have just 2 cases. This one is anyways very simple. Okay. So these are landmark cases with regard to false imprisonment. So in Bhim Singh, you are already aware that an MLA was wrongfully restricted from attending the assembly meetings by the other, like opposition, right? Opponents restricted him with the help of some executives and police officers. And then when the person has to be produced before magistrate within 48 hours. So when he was produced before magistrate, magistrate also said that, yes, it's fine. This arrest is valid only, you can arrest this person. So after this assembly got over, after that only this person was released. So he filed a case, and Supreme Court said that no, this arrest was not justified, and accordingly compensation of 50,000 was paid to the MLA. Okay, so this is a landmark case wherein compensation was given. Another one we have is Doodles Shah versus State of Bihar. This judgment came in the year 1983. In this case, petitioner and under trial was wrongfully confined for several years. Under trial, what is under trial? Do you know under trial? Under trial.
Ma'am, trial like 5 years, 7 years.
What is trial? Trial is basically the same thing I told you, right? If I say that, okay, this person has done a wrong, this person has killed C. Court is not going to believe my saying. Court is going to try the case, right? Court is going to hear witnesses, gather evidences and all that stuff. So this is called as trial. This entire step, right? This entire duration when court is deciding the matter, it is called as trial. Okay. And when we say under trial, that means one person, okay, there is one person against whom some allegations are there, and he is under trial. That means court is yet deciding the matter. Court has not yet acquitted him or convicted him. Final judgment has not come. He is under trial. The case is still going on. Okay, we similarly say under trial prisoner. That means this person is a prisoner. He is there behind bars in a jail, but he is an under trial prisoner. Court is still deciding on the matter. Okay, so in this case, the petitioner and under trial, this person, some allegations were made and this person was an under trial prisoner. Case was still being decided, was wrongfully confined in jail for several years despite his acquittal by court. Acquittal, I told you, right? That court finally concluded that this person's wrong is not established. You cannot punish this person. So once someone is acquitted by court, this person needs to be released from jail. But in this case, what happened is this person was not released from his jail, but he was confined there for several years, even after court acquitted him. So in this case, Supreme Court approved the order of High Court. Like first he went to High Court and then went to Supreme Court. So Supreme Court said that, yes, whatever order High Court of Patna has passed, that order is justified only. As soon as this person under trial is found not guilty by court, he should be set free. It was duty that once court established that this person is not guilty, he should have been released. If this person is not being released, there is false imprisonment. Okay, and accordingly, like an imprisonment compensation was given of total of 35,000. 5,000 was given previously, then after later stage 30,000. So total of 35,000 of compensation was given in this case, because after acquittal by court, this person should have been released from the jail, which was not done. All right, so another case we have, which is like very famous case. You can study this case properly. You will be getting this case in your like entire lifetime. Okay, in Constitution also you will get, in many other things you will get this case. Okay, so you can invest your time and read this case properly. It will not go in waste. Okay, so this case is D.K. Basu versus State of West Bengal, 1996. What happened basically in this case is, there was this person named D.K. Basu, who is the executive chairman of Legal Aid Services. Okay, West Bengal addressed a letter. He is basically chairman of this entity called Legal Aid Services. And on 26th of August, 1986, he wrote a letter to Chief Justice of India. Okay, he wrote a letter to Chief Justice of India, and he said that these are some articles which were being published in this Telegraph newspaper. Okay, he highlighted that these are certain things which are being published in this newspaper regarding deaths in police lockup and custody. When a person is inside police custody, the person is beaten up very badly, the person is killed, other sort of harassments are there. So regarding that, some news articles were published, and this person highlighted those articles and wrote a letter to Chief Justice of India. And he also said that this letter, what I am writing, that you need to consider this like a, you know, like a petition. You can consider it like a case only. Okay, you need to consider this as like a writ petition. And so Chief Justice also realized that yes, it's a very serious issue, and Chief Justice also said that yes, we are going to consider it like a public interest litigation. This letter only was converted into like a proper case. And accordingly, case was, case continued, everything was done. And finally, court realized that yes, this itself is a very major issue, that under trial prisoners or other prisoners in general are suffering a lot in the hands of police. That is why in this case, 11 guidelines were passed by the court, that these are some guidelines that needs to be followed inside prison also. So some of these guidelines are like, you cannot simply come and be like, okay, I'm arresting you, come with me. When someone is arresting that person's, this some name and some tag would be there, right? In police officers here, have you seen that their names or some designation, some stars and stuff would be there here? Have you noticed that? Or in their pocket, some names would be there.
Yes, ma'am. Yes, ma'am.
Right? So when some police officer is coming to arrest a person, his name, his designation should be properly visible in that badge, whatever they would apply. They should also inform that this is the thing which you have done for which I'm arresting you. They simply cannot be like, okay, come with me. Okay, they need to inform the reasons. Once someone is arrested, his family members should not know, right, that this person got arrested. So he should be allowed to make at least one phone call to inform some of his friends or family members that he is being arrested. He should also be told that this is so-and-so police station, you are being arrested here, and you have a right to consult a lawyer, you have a right to hire a lawyer. Okay, he should be allowed to talk to a lawyer privately. All those like different guidelines were being arrested just to ensure that police officers are not taking unfair advantage of their power, basically. Okay, so these cases and all also you can write 2-3 cases, like in short you can write basically that these are some landmark cases with regard to false imprisonment. Okay, so is this part clear? Is it clear? Any point you want to be repeated?
No, it's clear.
Almost clear? Almost clear or clear? Clear or almost clear?
I don't.
Hmm?
It's clear now. Once I grow through, if I have doubt, means I'll ask.
Okay, fine then. Okay, so I'll share it. You can go through it. If any point you have any doubts, you can ask. Okay. So fine, then we'll continue with some other remaining topic tomorrow. All right.